Hello and welcome. If you can hear me, please put a comment in the box. Comment anything so that I'm sure that you can listen to me. Hi, Carlos. Hello, everyone. We'll give 2 minutes more to people who are joining. Thanks, Carlos, for confirming that you can hear me. That's always a good sign. And let's wait a couple of minutes so that everyone else who wishes to join can join. Until then, please type into the comment box, where are you from? Type in the name of your country or city so that I can understand where are you from. For those of you joining in, please type in where are you from. Oh, very nice. We have Rishi from Trinidad, Carlos from Canada, Sanjeev from New Jersey, and Willem from Belgium. Hello, my fellow colleagues from Belgium, Wouter from Netherlands, Isabel from Brazil, Rishi from Trinidad and Caribbean, Wouter from and in this video over the next few minutes we are going to talk about privacy shield invalidation. And yes, we have Fabrice or Fabrics from Brazil as well, and in fact so many more people commenting. So thanks for joining, and let's begin. First and foremost, I know how important time is, and thanks to each one of you for taking time to be here and listen to this episode, this live. That's the most important thing, because if you are here, that's when our efforts become relevant. So thank you for being here. I appreciate your time, and I will do my best to make your times worth. So you all know the topic is privacy shield invalidation that happened a few weeks ago, and that's what we are going to talk in detail. But before I do that, I like to thank and extend my congrats to my dear friend Marcio and his team at Get Global, who've been doing fantastic work of bringing these things to you. I mean, people say there's no free lunch, but they make the free lunch possible. They make a free training every Monday to you, and we make it happen. So thank you, Get Global. Thank you, Marcio, for making things happen. And I see the number of people joining is also increasing. So is for you. In this session, we are going to talk about privacy shield invalidation. So the Court of Justice in European Union made a decision that privacy shield is invalid, and we are going to talk about different dimensions of it. So this session is for you. If hello, Oscar from Chile. If I don't shout out your name, don't get me wrong. I also want to do the presentation apart from calling your names, which I love to do, but I also like to do presentation. So if you have any questions, anything that you want to ask, please drop in your message in. I will keep an eye and I will make sure all the questions are answered. And if not, I make sure that we are afterwards getting back to you with answers. So anything you want to know about Privacy Shield, please put in, and I will explain what is it that we are going to cover. So we are going to discuss about what happened. What was the decision of the court? What did court decide? What exactly was it? Why does it matter? Yes, why does it matter, and who does it matter to? What's the impact for companies? And what are the choices for you in the short term? And then we will talk about what will happen in the long term. So you need to take certain actions now, and you need to take certain actions in the long term, and that's what we will talk. And then finally we will make a summary of things. So if you're joining late with us, thanks. Just type in, keep commenting, because it allows me to know that things are working well with technology. Sometimes it so happens that you're not listening and I'm speaking. It happened a couple of weeks back. I was speaking on Facebook and YouTube. I spoke for half an hour, and later on I realized the voice was not there. So it's not very pleasant to be that. So that's from then I started to ask you guys to be more participative and more active. Hello from India, from Tirupati. So thanks. And let's get started with what happened. And as I said, if you have any questions, please post them in. For those of you who do not know me, it's relevant that I share myself. Who am I? So I'm an author, speaker, and consultant. I help you in making privacy compliance or compliance with privacy laws like GDPR, CCPS simple and manageable. How do I do it? I do it through coaching, consulting, training, and advice. That is anything you want me to do for you. And I have had the privilege of writing three books on GDPR. One of them happens to be the all time best, and the other one happens to be the ninth best in all time GDPR books. Podcast wherein influencers like Marcio, my friend Anne Cavocchia of Privacy by Design, came in and shared her perspective. I'm offering online courses, coaching, and training to businesses and individuals. And I have in my past advised and mentored business and privacy professionals in 30 plus countries across the globe for GDPR compliance in Fortune 500 companies, a European bank, and a leading US manufacturer. And I'm certified in privacy. I don't tell you to make you like I'm great. The idea is I'm just like you. I have had some good fortune, but to assure you that in this session, I will take good care of you. I will do my best to give you the best in the next 30 to 45 minutes or 1 hour we will have. And the number of questions you ask will depend, the quality of questions you will ask will determine the quality of this session. The more engagement, the better it is. We already have a question from Carlos. Do you think there should be another agreement between US and EU? Yes, very good question. Let me take my notebook so that I note it down and make sure that I will answer it during the call, because the more questions will come, and then who knows, this goes beyond my eyesight and I forget it. New EU-US agreement. Yes, I believe in short, yes, but we will talk about it. Wow. What about agreement between Brazil and US? Yes, of course. And what about agreement between US and India and EU and India and so on? Why not? So that was a quick introduction about me, and let's get started. You may know that this is a complex topic. Why I say this is a complex topic? Because talking about laws, talking about data transfer involves a lot of law. So I would apologize. Normally my sessions are very simple. I do my simplification to the best, but still this session will have some terms that will be technical. So this is not for you if you don't know anything about privacy. This is for you if you know about privacy, you are an expert, and you want to learn about data transfers and what is the impact of uh, EU Supreme Court's decision about privacy invalidation. So let's have a look at some basics so that we are on the same page. The rule in EU is that when the data, the personal data about EU residents travels, the conditions, the standards of data protection travel with the data. So whatever data protection standards are available in the EU, the same must be provided in any other country if the data is traveling across. That's an obligation, and that's an obligation for data exporters. That is a company that exports data. So if a company A sitting in Europe collecting data of European citizens or residents is moving data to an entity in US or another company in US for processing purposes, or anywhere in the third country other than US, they have an obligation to protect this data. They have an obligation to make sure level of protection in US in the third country is at the level of EU. That is, standards principles as applied in EU GDPR are applied. So this also requires the data importer to inform the data exporter of any inability to comply. So if the company importing data in US or a third country is not able to justify, is not able to provide the standards in data protection, they must notify the exporter, and then they should discuss supplementary measures or decide to suspend or stop or notify the supervisory authority. So that's for context of what did happen on 16th of July or mid of July. So the Court of Justice in the European Union decided or confirmed that EU standards of data protection must travel with the data when the data goes overseas. So let's get this right. So if data from EU is moving to data in EU, And in EU, let's imagine standards were ABC. The same ABC standards must be applicable. Now, the data protection standards in the EU are GDPR. So GDPR equivalent data protection is expected. So this was already there in the GDPR, so nothing new. So court reaffirmed it. Then EU citizens do not, yes, that's important. EU citizens do not enjoy the level of protection demanded by EU laws when their data is transferred to US. What does this mean? The court said the level of protection in the United States is not the same as EU. And that's where the whole story stems or whole story builds up. This means the judgment has wider implications over and above the privacy shield, because privacy shield was an instrument. So when a company is transferring personal data from EU to another country, there are some mechanisms they can use. They can, if it's with US, they could in the past use privacy shield. So privacy shield is the same thing as safe harbor agreement. It came out of the safe harbor agreement, and both governments and the relevant authorities agreed that privacy shield is the mechanism. But the court judgment said that privacy shield level of protection is not sufficient, and it confirmed the importance of safeguards to be applied. So this has a direct consequence if your company was using privacy shield for data transfers. Now, whatever mechanism is used to transfer this data, even to third country, the protection afforded to EU citizens should be equivalent to what is available in EU. So after that, there has been a lot of discussion, a lot of input from almost all the data protection authorities in EU, and even reactions from US, and there are things in progress. So the EDPB, the European Data Protection Board, has recommended that you must conduct a risk assessment as to whether the standard contractual clauses or binding corporate rules are sufficient and providing enough protection within the legal framework, whether transferred to US or elsewhere. And that's significant. So what happened? In short, the court invalidated privacy shield. The court said standards of EU will travel, and then it creates actions for companies. So far so good. Keep saying something so that I know you are active, I'm active, and you are hearing me. And if anything you want to hear, ask questions. This session is for you. So if this is what happened, what did court examine? So court had examined the adequacy of protection provided by EU privacy shield. Why? There's a privacy activist named Max Kerms. This was the second judgment in his case, and wherein he challenged that US privacy shield, especially when data is being transferred by Facebook based on that, is not sufficient. And the court answered in his favor. So now, why does this matter? Why is it so important? It is important because there were three different means for transferring personal data from EU to a third country. If it's US, you could use privacy shield. If it is any other country or US, you could use standard contractual clauses. For those of you who do not know what are standard contractual clauses, these are set of standard legal terms which are provided by the EU for usage in your contract. So far, you would take the standard contractual clauses, put it in your contract, and you thought it's done. It's not the case now, and that's what we will talk about. And then the third thing was binding corporate rules. So if you are transferring data within your entity, so company A and company B from the same company group, when they were transferring data between themselves, there was something called binding corporate rules. So what are binding corporate rules in short? These are internal policies of company which facilitate data transfer, but they are validated by a supervisory authority. So unless and until your binding corporate rules are not validated, they are not effective, or sometimes you can implement them and get them validated in parallel. That's also a possibility. Someone is asking, how can we assess the risk of leaking data to US institution, and how can we measure the risk? That's a good question. Risk of leakage, I'm not sure we will cover it in depth, but I will do my best to take that up. So thanks, Willem, for asking that. And Now the question is, if you are using standard contract, it's clear that if you are using privacy shield, you have to act. But what if you are using standard contractual clauses or binding corporate rules? And that's a very important question, and that is what we will get into. Now, who does this matter to? This matters to any company that is transferring personal data outside of EU. Now you will say, I've been talking about in context of US, and all of a sudden I say anywhere outside of EU. The reason is the court said that standards within the EU go along with the data, and it didn't say only for US. So that's why I'm mentioning that it will impact all data transfer. You will need to review all data transfers, and it matters to both the importers and exporters of data. So in GDPR, we call the exporter as controller and importer as processor if there are certain conditions are met. But exporter and importer are simpler terms, saying the company exporting data, importer meaning importing the data. So that's how it works. So it will impact any company that is processing or asking another company to process data, its own legal entity or another company outside of EU. Now there are four scenarios I will discuss about, because if we have to discuss the short term impact, it's best that we look at it through scenario. So scenario one is transferring data to US relying on privacy shield. So scenario is, you as a company were transferring data outside of EU using privacy shield, whether within the company, that is intra company transfers, or outside the company. I think it's very clear. Since privacy shield is invalidated, you have no choice. You have but two options. One, stop that transfer if possible. I know it's easier said than done. Or look for alternative means and mechanisms in which you can assure that the importer is providing safeguards equivalent of EU. So scenario one, reliance on privacy shield, massive impact. That is, find a new mechanism of transfer because privacy shield is invalidated. When do you need to do it? Immediately. I'm sorry. The court did not give any lead time. Like when the EU GDPR came into effect in 2016, the law gave 2 years to May 2018 for compliance. But in this privacy shield invalidation, it's immediate. You would have seen some mails from the company with G saying we are, yeah, the way you search everything, uh, saying we are moving to standard contractual clauses plus some conditions, and we have updated our terms and conditions. So that's the same thing you have to do. My bank didn't do it yet, my email providers, some of the others didn't do it, my website provider didn't do it, but that's an action everyone has to take. And if you need any help, any pair of extra hands and ears and eyes, I'm there to help you. So first, privacy shield, full impact, take action, your contracts are not valid. Second, you were using standard contractual clauses. So the clauses provided by EU as standard, and you are embedding them as is into the new contract or the contracts. And we are so far talking about all the existing contracts. Yes. And focus on US. Now, normally everyone thought, since the standard contractual clauses are not invalidated, yes, important, not invalidated, the impact is limited. But when I read this judgment, and when I read the guidance from EDPB and the ICO and some others, it's heavy impact. The first thing they say is whether or not you can transfer personal data based on standard contractual clauses will depend on the result of your assessment. Big change. Earlier, use standard contractual clauses, no need for assessment. Now you need an assessment. Consider the circumstances of transfer and consider if additional measures in addition to standard contractual clauses are needed. So the first action is do an assessment, even if you are using standard contractual clauses. Second action, consider implementing supplementary measures along with standard contractual clauses, following a case-by-case analysis of circumstances surrounding the transfer. So you need to look at each and every aspect of data transfer and check if there is adequate protection. And would then you ensure that US law does not impinge on adequate protection. Now, there are two scenarios, or rather three. One, you find it adequate. Second, you find it inadequate, and something is in between. Normally, you'll have some gaps. Yes, there's a question, can DPIA be used? That's a good question. Normally, you need to conduct an assessment. DPIA can suffice also, but in DPIA, you need to specify what are the different points you are checking in terms of adequacy. So you need to identify the adequacy points and then perform the DPIA. So Rishi, good point. You can consider DPIA as an assessment tool as well. Now, if you conclude, considering the circumstances and possible supplementary measures, that appropriate safeguards are not ensured, yes, the negative scenario. So standard contractual clause is being used and you conclude after assessment it's not sufficient. You have two choices, or maybe three. One is you suspend the transfer, that's what, or end the transfer, that is what is being recommended by European Data Protection Board. However, if you are intending to use, that is continue to keep transferring data despite this, which is dangerous, I would recommend you that you must notify your competent supervisory authority. So this is very tricky. I mean, imagine I'm in a company A, I conduct an assessment, I find out that it's not sufficient. My management says we will continue, we won't change. And what are you going to tell your supervisory authority? We identified it is not sufficient, but we are going to continue. That's called shooting yourself in the head. Sorry for that acronym, but that's how it is. So don't do that, in my opinion. Take some action. Summarizing, if you are using standard contractual clauses with a data importer in the US, you will do an assessment. After that assessment, as Rishi said, can be a DPIA assessment. That's better, with specific focus on different circumstances and the measures that are available. And then you check if the protection is sufficient or not. If it is, good for you. If it is not, you need to either stop or inform the regulator that you're continuing, or take action. And I think take action is the best option. If you find it's not sufficient and you continue, or you inform supervisory authority, it's not going to work in the long term. So only option is to fix it. So that was standard contractual clauses with data importer in the US. Now, what if you are using binding corporate rules? So binding corporate rules, as we said, are used within the company. So one entity, say in Belgium or Netherlands, transferring to an entity in US based on privacy, based on binding corporate rules. So given the judgment of the court, which said privacy shield is invalidated and did not touch upon BCRs or standard contractual clauses, prima facie, it seemed that you don't need to take action. But if you read it in the detail, you'll find out it says, irrespective of the mechanism being used, you as data exporter have the responsibility, have the obligation. And that's a big change. Earlier, with the binding corporate rules, with the standard contractual clauses, since they were validated, provided by supervisory authorities, you could use them. Now, you have the additional obligation to conduct an assessment, which means you just cannot say, I use the standard contractual clauses. You use standard contractual clauses, but you need to use judgment, assessment. And that's where the big impact is. So it's the same thing. Whether or not you transfer personal data based on BCRs will depend on the result of assessment. So it's not a BCR decision, it's an assessment-based decision. That takes into account circumstances and supplementary measures that could be put in place. You're not only going to look at what is in place, but also supplementary measures. So again, as our friend Rishi said, you can consider a DPIA evaluating circumstances as well as supplementary conditions. And then these supplementary conditions, measures, along with BCRs, following a case-by-case analysis of the circumstances surrounding the transfer. So you look at each case, each scenario, and you would have to ensure that US law does not impinge on adequate level of protection they guarantee. And that's going to be challenging, because once the data is in the EU, out of the EU and in any other country, especially US, it's bound by the laws of US, because you cannot say to the government, it's coming from EU, we cannot. So that's going to be challenging. But what if the result of that is positive? Good, nothing to do. If the result of that is negative, it's challenging. One idea, you suspend or end the transfer. Very challenging at short notice. Second, you notify your competent SA service supervisory authority that you are intending to keep transferring data despite this conclusion. Again, just like standard contractual clauses, very dangerous. Won't recommend it. That you go to your supervisory authority and say, hey, we find it's not sufficient, but we are doing it. Good luck if you want to do that. So somebody is saying, so I'm right in assuming that ruling places more responsibility on control to ensure that data transfer meets EU standard regardless of standard contractual clauses or BCR. Spot on, Rishi. That is exactly what it means. You use whatever mechanism, but do an assessment and take responsibility. It was always clear in the EU GDPR that the responsibility, the obligation was with the data controller or the exporter. And now it's explicit. Earlier, it was possible that if you're using BCRs and standard contractual clauses, you don't need to do additional due diligence. But now you need to. Yes. So you're right. So scenario 3, you're using binding corporate rules with an entity in the US. Assessment based on result, you take action. Actions being fix, suspend, or notify the authority that we found insufficient protection and we are continuing. Not recommended. A lot of work again. Now the fourth scenario, which combines other scenarios, but let's imagine you are transferring data outside or other than EU, outside EU, but other than US. So it's not EU US, not in context of privacy shield. So in that case, what you would be using is two options. One is a standard contractual clause or a binding corporate rule. Standard contractual clause if it's an external company. You can also use it in the internal company, but binding corporate rules if and only if it's an intra-company transfer, that is transfer within the entities of company. This has huge impact for countries like India or anywhere outside of EU. So all countries that do not have adequacy. So what is adequacy? Certain countries like New Zealand, Isle of Man, and some other countries are given a status, like Japan has recently been given that status called adequate protection. That is, these countries are identified by EU as offering adequate protection. Adequate meaning same level of protection as in EU, unless you're transferring to any other country. By the way, India, US are not in that list, or in fact, 6 or 7 countries. So a lot of countries are not in the list. If you're imagining, I just mentioned two to name a few, because a lot of people outsource to US or to India. Somebody was talking about EU US trade being 7 billion or 7 trillion, and it's going to impact 7 trillion of trade. Yes, in nutshell, but it's a little bit of over the top exaggeration. Not all trade happens based on personal data. Not all trade is a data export, not data import. So it's good for sensationalization, but putting it in context only if you are trading data and you are asking for processing. So not a 7 trillion impact, a little bit less. How much? Difficult to quantify. So if you are using standard contractual clauses or BCRs to transfer data to a third country, what will you do? 3 actions again. 1, you need to understand it is the responsibility of data exporter and importer. Yes, not just the exporter, also the importer. Whether the level of protection required by EU law is respected by third country concerned, in order to determine if guarantees provided by BCRs or standard contractual clauses can be complied. So standard contractual clauses or BCR say these are the guarantees that must be provided. Now data exporter and importer need to evaluate if those can be actually practiced, can be practically achieved, and that's going to be tricky. For example, specifically talking about India, a privacy law is still in consideration, it's in final stages, so it's going to be challenging, and that's where additional measures need to be put in place. So what you are going to do is, in that case, you're also going to do, if this is the case, you should assess, same thing, assessment, whether you can provide supplementary measures to ensure essentials. So whatever is given, you add supplementary measures as provided in the EEA, and if the law of third country will not impinge on these supplementary measures so as to prevent the effectiveness of data protection conditions. Almost the same thing which we said in the US thing. What if you conclude that the data protection standard is sufficient? Good, congratulations, you don't need to take any action. However, if it's not sufficient, you can contact your data importer, collaborate with them, and find out what to do. Or you can stop. But if you don't stop and you decide to continue despite conclusion that the protection is not adequate, what you're going to do? You're going to inform the data supervisory authority. Again, very, very, very challenging. I cannot see how can a company go to an authority and say, we analyzed, it was not sufficient, but we are going it anyway. Not possible, not recommended, not practical. Another question, what are your views on organizations in Caribbean that will collect data from subjects, say hotels, and use of data processes in the US to store, process, or so my opinion is if it's data of US residents, it's the US law which will apply. But if it's the status of it's the data about EU residents, the EU GDPR would apply, and all these conditions will have to be met even in the Caribbean. It's between Caribbean and US law, but it will not apply the EU GDPR unless the person is a EU GDPR citizen, EU citizen, not GDPR citizen. There's nothing called GDPR citizen, by the way. So those were the four scenarios, and let's condense everything into actions. But before that, give me a yes if it's still being useful. If it's not being too technical, give me a yes. Type yes in the comments so that I know it's going well. You guys are catching up. Or if there's something which was unclear in these scenarios, I can repeat that scenario. Just say yes or no, of course. I mean, if it was not, if you're saying no, please specify which scenario. I will highlight that scenario. I'm looking forward to some yeses. Okay, yes, yes, very good and simple to follow. So thanks. And those of you who are hesitating to say yes, I would say no in that case. So I can at least explain you say no and which scenario you didn't get it, or I didn't explain well, then I can help you out. So thanks, Isabel, Vivek, Rishi, everybody. Yes, the questions were for EU citizens. If the questions are for EU citizens, yes, the EU GDPR would apply. So now let's condense and summarize all the actions that we've talked about. First and foremost, if I was in your organization and I was helping you out, I would recommend four actions. First and foremost, go and check your contracts with data transfer to US. That's the first thing I will do. Identify what is the basis of transfer. First step, go into your organization, check the data transfer to US and identify the basis for transfer. And I will, obviously, there will be three categories based on privacy shield, based on standard contractual clauses, based on BCRs. If your company has BCRs, you will have maximum three such categories of contracts. And I would put focus on privacy shield first because those contracts have to be rewritten. Second, I will put focus on standard contractual clauses because those usually are outside the company. And third, I will put focus on binding corporate rules. Why I put binding corporate rules third is because they are within your company. You have more control. You have less risk relatively. I didn't say no risk, less relatively. So first, focus on privacy shield, second on standard contractual clauses, and third on the BCRs. Now review inline the advice that I've given you in different scenarios and based on the priorities I've advised. Then you ensure that all the provisions in Article 46, Chapter 5 of GDPR are applied. Yes. I never use articles or chapters, but here I need to because it's about the law and it's protecting your company. So what you need to do is go to Article 6, Chapter 5, read the conditions and make sure all the provisions are implemented in your contract. That is the new contract. So that's what you will do. Check all contracts, classify them, prioritize them, review the inline the scenarios I suggested, and ensure all provisions are implemented. Once that is done and dusted for US, then you start the same three steps with countries other than the US. Yes, it's challenging, it's painful, but that's how it is. And that's how it will be in the short term because there's no other choice. You need to do it, you need to prove it. And especially if you're a large company like a bank or an insurer or a pharma or a telco, like some of my old colleagues, yeah, it's a lot of work. And that's how it's going to be. So take these four actions in short. That's the short term effort that you will have. Now, what will happen in the long term? You will do all this. And there was also a question, what about uh, the new EU-US mechanisms? Yes, that is something will happen in coming week, not weeks, months and years. I had heard from someone in EU that they were already working on standard contractual clauses. I don't know if they were aware of this coming or otherwise, but they were working on standard contractual clauses. So a new version of standard contractual clauses is due, is likely, I don't know when, but soon. Since it's about law, we don't know what the soon is. So don't ask me that question when. I don't know, but it's in progress. So a new version of standard contractual clauses will come soon. So that's in the long term. And then once it comes, you'll need to use that in your new contractual clauses. I read a news which said the discussions between the US and EU governments have started and a solution like Privacy Shield is being explored. So if that happens, you'll have another mechanism. But my recommendation is don't wait for that. Do the assessment and take the action as necessary. And any of these two things that happen, standard contractual clauses or a privacy shield solution, it is likely to bring more work, more changes, more things to do. I'm sorry for that. I know we don't want to work on contracts which are already done, but that's how it will be. By the way, keep asking your questions. I think I've answered the new US uh, assignment. I've answered the DPIA. And there was a question about Brazil and US. So let me take that now because we are at the right moment. So between Brazil and US, I'm not aware of the details, but if it's a data of non-EU citizens, it's between the two countries. The US has the Brazil has a new law that comes into effect May 2021. It was to come into effect this year, but because of pandemic, it's postponed. So what will happen is you need to take that in function of those laws if it's non-EU citizens. If it's EU residents, EU GDPR or the level of protection in EU would apply. In fact, what happens after Brexit, that's also another scenario, but let's leave that complexity aside. The other question was risk of leakage. What was the question? Yeah, how can we assess the risk of leaking data to US institutions? How can we measure that such a risk? That's a very good and very smart question. I wish it was a quick answer. I think an assessment, a DPIA with full team of a lawyer, a US and somebody knowledgeable about US law, all the stakeholders, they need to assess it and evaluate. Essentially, it boils down to the main concern in the court assessment was the surveillance or the interventions by the government. So you're talking about that any authority can ask and leak data. Yes, that risk remains, but how can you ascertain? Only through an assessment, no other way. So with that, we've had tackled all the questions that were asked. So you need to ask new questions or type something in so that I know the connection is still working. So please type yes, it's still useful. Yes, the voice is there or something like that. So say yes for voice and say no more questions or write your questions. I think that's the most important thing. We still have about 22 minutes. And if you ask questions, we can use that. Otherwise, it will get over very fast. So I have so far covered what happened. Why was it significant? What was the impact and who does it impact and different scenarios and what are the actions in the short term and in the long term. So in summary, the Court of Justice in the EU has decided that when data travels to any other country other than EU, the standards of EU travel, first thing. It also decided that the protection in the US is not sufficient, which meant privacy shield is invalidated. It did not invalidate standard contractual clauses or binding corporate rules, but it did say it's the responsibility, the obligation of data exporter to make an assessment even when using any of the formats. Even if you are using standard contractual clauses, even if you are using the binding corporate rules, it is obligation of the exporter to make sure to assess if the level of protection is similar or not, and that's irrespective of whether US or EU. Third, we talked about fix the US transfers relying on privacy shield. Then we talked about review all other data transfers. Yes, data transfers to any country irrespective of US, that is outside of EU. We are not talking about adequate countries. And if you do that, do an assessment, evaluate, take corrective action, and corrective action is fix things or suspend. The third option of going back to others is not possible. Can you give an example of standard contractual clause or binding corporate rules? That's a good question, Sanjeev. Let me handle that right away. So, okay, let me imagine that I'm a European bank and I want to transfer some of the payroll processing to an outsourcing company. So payroll processing to an outside company. So it's outside my region. And in that case, I choose two companies. So global companies, because if I choose Belgium or Netherlands, it will be SD Works or something. But let's say I want to use Workday, which is more or less a global solution. And they have a server in US and they have a server in India. So now Workday is not the bank or the insurer in which I'm working, and Workday is another company. Previously, I had two mechanisms. I could use privacy shield for the US part and standard contractual clauses for the other part. Since these are two different, I will use standard contractual clauses. Standard contractual clauses meaning you go to the EU website, find out the standard contractual clauses. It's set of a few pages. You just add them into your contract. That's how it used to work. These are set of standard terms, how data protection is to be ensured in the EU. Then once you have put them, it was fine. But now you don't just put them, you evaluate the standard contractual clauses and check if with the standard contractual clauses, along with the laws in that country, will the data protection be sufficient? If you evaluate yes, you can go ahead. If not, you need to take corrective action. And if you decide that it's not going to be possible to take corrective action, you need to stop. And if you still decide to go ahead, that is not stop, you need to inform the supervisory authority. So that's how you will use standard contractual clauses. There's also a question from Tirupati B that explain the standard contractual clauses. Was it clear, the standard contractual clauses? Then I move to BCRs. Or you want me to explain in more in depth? I read the main problem about EU versus US data transfer privacy shield cancellation is that US has no national data authority. What standard contractual should do about it? Okay, we will tackle that, but first I want to make sure that you have clarity on the standard contractual clauses. It was from Sanjeev and Tirupati. Of course, anyone else is also free to answer. Is this standard contractual clauses thing clear? Yes or no, or maybe. Those are the three options. We can't invent more. No, sir. Okay, that's clear. Very good. So let me take another example. And this time I'll simplify. So let's take the example of, you wanted an example clause. Okay, that's somebody asked me, often clients ask me, what do we have to use as standard contractual clause? I have it with me in my privacy kit, which I distribute to clients. So privacy kit is a set of about 25 plus documents, which I provide to them for compliance with EU GDPR or data transfers. Let me get there. Bear with me for a minute. Privacy. So I need to find the privacy kit documents. Here are they. Standard contractual clauses. So somebody, I think Sanjeev asked, how do they look? So there are two standard contractual clauses: data transfer to a processor or data transfer to a controller. So the example we were talking of was data transfer to a processor. In that case, what will happen? It will be a, so two standard contractual clauses. You will use the standard contractual clause for transference to processors. So if you do that, such a document would contain, I hope you are still able to see me because I moved to screen. If you are able to see me, just put in yes, so that I know even when I'm on the browser, you are able to see me from the camera. Just say yes, or of course, if you're not able to see me, say no. Yes, that's good news. Thank you for confirming that. I'm just opening the document. So standard contractual for processes, what does it contain? It defines personal data, it defines the response, who is data exporter, who's data importer, it defines data processor, it defines the details of transfer, and then it has third-party beneficiary clause. And it has the conditions and obligations for data exporter, that is the company that exporting data, like they will respect personal data, they will collect personal data fairly, they will ensure sufficient guarantees are provided, they will do an assessment of requirements, which was anyway stated in that, ensure compliance with security measures, and they will transfer security personal data or categories of personal data only if compliant with the law. So it has clauses like this, and then it has obligations for data importer, that is, what are they supposed to do? They are supposed to follow the instructions of data exporter. They have no reason to believe that legislation applicable to them prevents them from fulfilling, that is, they assure the exporter that relevant conditions are met. They will implement technical and organizational measures. They will notify data exporter immediately or promptly if they cannot fulfill the obligations, or there's a loss or there's a breach, things like that. And they will provide a copy of clauses and the liability conditions, and then mediation and jurisdiction. So in short, if you are able to follow, that's good. Otherwise, let me make a quick summary. It lists out the obligations for data exporter and data importers in a standard way. So normally you do it in the data processing agreement, but here you have a standard contract. You don't have to see, Sanjeev, my browser screen. Sorry for that. I meant you have to see my face, the video, because in this tool, we don't have the functionality to share screen. So I was reading it and sharing it, but I wanted to make sure that you are seeing the video. The video is not disrupted. So if it's still not clear, just email me at info@punitbhatia.com, info@punitbhatia.com, and I will share with you a copy of standard contractual clauses or a link to them. Or even better, I think someone from Marchio's team can put the link to standard contractual clauses in the YouTube, or I will put it myself after this. So we will do both. I will put the link into the link to standard contractual clauses from EU website. And if you still need have any questions, just ask me. info@punitbhatia.com. So there were a few more questions in between. Yeah, you were asking about binding corporate rules. So binding corporate rules is most companies. By the way, I hope this is more clearer now. I know it's a complicated topic. If you're not used to it, it takes a bit of time to get used to it. I hope you're getting a bit of sense about what it is. Okay, Rishi already pasted the link. So thanks, Rishi. Uh, yes, so Sanjeev is saying it's better. Thanks, Sanjeev. Glad that it's clearer now. You were also asking about BCRs. So binding corporate rules is a mechanism that used in intra-company. So let's imagine there's a company, like one of my or two of my previous employers were global companies. Many of them were global companies, but two with whom I worked in data protection. So if the company in Belgium or Netherlands wanted to transfer data to the company in US, that is the same company, ABC company unit Netherlands, ABC company unit US, wants to exchange data, they had, of course, the choice of relying on standard contractual clauses, or they could define an internal data privacy policy, get it validated with EU, And this policy would list out the requirements of GDPR kind of thing, but in a more simplified way. When it's validated by the European Supervisory Authority, like I'm here talking about a company in Netherlands or Belgium, so you'll go to the Belgium Supervisory Authority and say, we want to publish this as binding corporate rules. They would evaluate and they will send it to all the 27 EU member states. They will validate and so sorry, say to you that it's okay, the policy. Don't expect it to be an easy process. It takes 12 to 18 months or even more sometimes. It's a long process. So then binding corporate rules are defined, and intra company, that is within the company, rather than standard contractual clauses, would be defined based on binding corporate rules, which is a smaller contract, says based on the binding corporate rule, section this, we are transferring this data. So it's a quick process. So when I was with the ING Bank, they used to rely on binding corporate rules. And when I was with the Stanley Black, and of course they relied on many other mechanisms, but that was one of the mechanisms they were relying on. And same with when Stanley Black and Decker was the global privacy manager, they were relying on other means than binding corporate rules. So like Facebook relies on standard contractual clauses, and now they need to do an assessment. So okay, what were the other question? There was another question by someone. I think I missed it. No, let me go. I read main problem about, yeah, help me out, binding corporate rules, okay or not? So if you're transferring from Netherlands or Belgium to US company, your own company's sub company, you will use binding corporate rules. So that's a lighter way of doing it, less administrative process. So help me out, say yes, binding corporate rules, or no binding corporate rules. Then I'll give you another example. I need the main problem of EU EOX data model transfer privacy shield is that US has no national. Insofar I'm aware of, US has no national data authority on privacy, but they have state-wise authorities. They also have the federal, what is it called? Fair Information Privacy Practices, called FIPS. There's a FIPS Act which was passed in 1974. Of course, you'll realize something that was passed in 1974, and we are talking about in 2020. 1974, there was no internet, no iPhone, no data transfers like this or digitization. So how well relevant it will be, but from a principles perspective, that FIPS is a very important thing. All the world laws are essentially around the same FIPS, the Fair Information Privacy Principles. So yes, insofar I'm available, there's no data protection authority in the US, but they have the Freedom of Information Act and the FIPS combined. It's not exactly like the EU regulation, but it says it's like the US GAAP. So it's a more commonly accepted principle. And then standard contractual clauses and binding corporate should do about it. What should they do about it? Well, here, when we are talking about standard contractual clauses or binding corporate rules, we are talking about in context of EU. So the simple way is, whatever you need to assess the protection in EU is being replicated in the country or not. So it has nothing to do with US Data Protection Authority. Of course, if there was a US Data Protection Authority, it would have helped, but it doesn't matter. I hope, Isabel, that's clearer for you. If not, just give me a shout here and I will make sure that I get back to that. I don't see any more questions here, but if there are, please shoot now. I'll just take a pause so that you can put some questions. Yeah, Isabel, thanks. I'm glad to be of help. And if you need something, as I said, put in an email and we can talk. Okay, so since there are no more questions, I think I'll start the wind up procedure, or as we call it. So thank you so much for being here. We do not see for the link for SCCs. Sanjeev, I will make sure at the moment. I like to focus on one thing. I did try the standard contractual clauses reading, but after the chat, I will put a link in the YouTube and in the comment section from saying these are the links for standard contractual clauses. And if still, I mean, Sanjeev, you are well connected with me. So any of the channels that you are connected, you can ask me and I will give you the link otherwise also. But I will put it for everyone in the chat of the comment section of YouTube channel of the Get Global. I was talking to you about the Fit for Privacy podcast. Interestingly, that is ranked number 3 in the top 5 GDPR podcast by FeedSpot. I don't say this to impress you, but I say this to share with you that it's a worthwhile podcast to listen. And in fact, my dear friend Marcio is due in October in that podcast very soon. So, and we are having a wonderful conversation on global privacy and what Get Global and my company are doing and how we serve international privacy clients or companies. So do take a listen to the Fit for Privacy podcast. And if you haven't looked at my books, look at my book, Be Ready for GDPR. That's quite popular. And if you have already purchased it or had it, please do write a review. That always helps. And with that, I would love to thank you for your kind attention, staying through, because I see consistently, barring one or two people, everyone stayed in. So I'm highly pleased to see that every one of you stayed through and were here. So thank you so much for your attention. I appreciate. If it's useful for somebody else, please do share, because that's how we help Get Global, we help me, and we help others who need this information. And if you need anything, Marcio and me are here to help you, serve you, and ask us anything. So stay blessed, stay safe, and take care. And thanks to everyone who joined: Rishi, Sanjeev, Willem. I'm just reading out a few of the last comments. Wouter, Sanjeev, Tirupati, Willem, and Carlos, and Isabel. I'm running out of space and time because that's how it is. And Ostarin, so all of you, thank you so much. So happy to have you all. And in fact, some of my colleagues uh, from things. So thank you so much, and see you in the next episode next week. I'm not there next week, but one of our colleagues would be there, and he or she would take good care of you guys. Thanks. Stay blessed. Stay happy, and enjoy your day, evening, morning, or night, whatever it is. Enjoy. Take care. Bye bye. I'm ending it now.